Hi friends, today's topic Sale of Goods Act 1930. The topic chosen implied conditions in a contract of sale. First condition as to title, section 14 clause A. The seller must have a better title to the goods. That means the title here means true owner of the goods. The seller should be the real owner of the goods. Otherwise, the buyer can repudiate the contract. I would like to explain with a case law, Rowland versus Devine. In this case, R purchased a car from D. After paying the agreed amount, the buyer took delivery of the car. After a few months, he received a legal notice through a court of law from the original owner, stating that he should return the car to the original owner. It was held that since the car was a stolen one and the seller who sold the car does not have a better title to the goods, therefore the buyer should return the car to the original owner. However, he can recover the amount he has paid to the seller. Second condition as to sale by description, section 15. It is implied that the goods sold should correspond with the description. Otherwise, the buyer can repudiate the contract. Here, there are three classes. First one, when the buyer has not seen the goods, for which there is one case law, Worley versus Whip. In this case, a machine was sold describing it to be 1 year old and sale took place. Subsequently, upon usage, it was found that the machine was extremely old and did not perform as described. So a case was filed and judgment came that the buyer could reject the contract and recover the amount paid to the seller after returning the machine purchased. In the second category B, when the buyer has seen the goods but buys only on the basis of the seller description. Here also there is one case law, Bailey versus Taylor. In this case, a car was described as Herald convertible 1961 model and sold. The buyer has seen the car and bought on the basis of the seller's description. He believed the description given by the seller. Later, he found that the rear part of the car coincides with the 1961 model, but the front part was of a much earlier model. So, therefore, a case was filed. It was held that the buyer could return the car and get back the money paid, since the description was a false one. Third clause, packing of goods may sometimes be a part of the description. Here, packing of goods plays a vital role. There is one case law, Morey and Company versus Lander and Company, 1921. Here, M sold to L 300 tins Australian fruits packed in cases, each containing 30 tins. M tendered a substantial portion in cases containing 24 tins. Here also a case was filed and it was held that L could return the goods and reject the contract, since the goods were not packed according to the description given. Third condition, sale by description as well as sample. Here, the goods sold must correspond not only with the description but also with the sample. Here also there is one famous British case law, Wallis versus Pratt, 1911. In a contract of sale, certain quantity of seeds described as common English Shanford was sold. The seeds supplied was of a different kind. though the difference was not discoverable except by showing. The defect was also existed in the sample also. A case was filed and it was held that the buyer was entitled to recover the damages for the breach of condition. So, in my next lesson, let me continue with the remaining conditions. Thank you so much for watching this video.